All right, I think we're alive. Good morning, John. How you doing, my friend?
Not too bad, sir.
Good to see you. Guys, welcome to another episode of NOMBERG Law Live. As we do each week, we come to you on Tuesdays at 10 o'clock Central, 8 a.m. Pacific, and we try to have interesting guests talking about interesting things. And today is certainly no exception. I've got my friend Jon Rehm from Nebraska. He's an
Howdy.
attorney and has a very similar practice that David and I do, and we'll get into that as we talk about social media and its impact on cases. John, good morning, and if you would just introduce yourself and tell us a little bit about you.
Well, I'm Jon Rehm. I am a lawyer here in Lincoln, Nebraska. I've been practicing since 2005. I kind of like you. It's a my dad Rod started this firm, and I've continued on and I practice. I don't have any brothers or sisters I practice with, but there's three other law partners here. Live here in Lincoln with my, which is capital Nebraska, where the Memorial Stadium's at for you college football fans down in SEC country.
Yeah, we don't have any of those around here.
Yeah, none of that. So yeah, I live here in Lincoln. Really practice law all over the state of Nebraska. Nebraska is kind of a small state population-wise, but really big area. I think it's bigger in area than Alabama, but we only have like 2 million people, so I travel quite a bit throughout rural Nebraska, even in metropolitan Nebraska. I got my wife's an eighth grade teacher, so and I have a soon to be 4-year-old son Russell, and I just returned from the Dinosaur Station Park in Wichita, Kansas, which has all these animatronic dinosaurs that my son really liked. So
I bet that was so much fun.
yeah, it was. It was. Little kids are happy just to go to a hotel with a pool. So it's easy at that age, real easy. So, but yeah, that's a little bit about me, and I do a lot of blogging too about law practice, about workers' comp, about employment law, in particular, and I think that's kind of how this this interview kind of came about. I think.
That's exactly right.
But
I saw
anyway.
I saw a blog that you did a few months ago that deals with social media, and I saw that we had so many things in common. You mentioned earlier that your dad is a partner, I assume a founding member of the firm. We're kind of similar in that our father, he's now of counsel. He's happily retired down on the Gulf Coast, but he still stays in touch with David and me quite a bit. Just wants to keep his hand in, see what's going on.
Absolutely, yeah. So, but yeah, that's our firm. So yeah, and again, the social media is a real relevant topic. That's how kind of you and I connected too. Is like you were out there a lot, and I'm kind of out there, and we're kind of doing the same thing. And we're both in some other organizations together, but social media it's different. I don't know that we would have been having this conversation 10 years ago before social media bloomed. So
yeah, if it's not this, it would have been something else about how to manage some of the actions that your clients do so they don't harm their cases. But you're right. Back in February, March, I read a blog that you did about social media, and that's what led us to getting into contact with each other. And even though I'm here in Alabama and practice work comp like you guys do in Nebraska, our laws are so different and the way that they're treated. But what is the commonality, and it doesn't matter what state it is you have clients you're dealing with who have been through a very stressful period, or they're still in that stressful period. They've been hurt on the job. So all of life's stresses just ramp up for them. And one of the things that we do, and I've noticed from all that I've seen what you guys do, is you do such a great job of informing your clients about the information that they need to help lessen a little bit of that stress. So before we get into the social media aspect, John, talk to us just a little bit about how you guys keep your clients informed, how you educate them during this process of representation during their comp case.
Well, I mean, obviously it starts when you talk to people on the intake process when you're talking to a new client. Tell them about it's communication, talking with people during the process, and just reminding people what's going on. I think clients at least in Nebraska, we have written questions called interrogatories, and a lot of them are just like worksheets and paperwork, and people don't like that. So, I mean, all throughout the court process, you try to communicate with people. Obviously, we try to educate the broader public through use of social media, through use of blogs, through use of Facebook, but it's just with communication with our clients. I mean, and again, I think we try to we try to educate, the broad public about workers' comp through blogging and social media. But when people are actually our clients, you start, first thing you explain what workers' compensation is. You explain how maybe it's different than a personal injury case, and then the more as the case goes, you're talking to people. So it's just client communication. And I think what's different now is that we can put more of that stuff online, and people can read about it and at least know something coming in, whereas before, maybe 10, 15 years ago, there'd be less knowledge. So
you're exactly right. That's one of the great things about social media, at least from our practice, and yours may be very similar, is that the average client, and this can be dangerous as well, they've read a whole lot more, think they know a whole lot more than they did before the advent of social media and all this information being so readily available. But one of the things that I really like is when a potential caller or new client gets in touch with me and says, I kind of feel like I already know you. I've watched a lot of your videos. I've read your blog posts and those kind of things. So that kind of secures to me that at least some of the information we're putting out there is being read and consumed by potential new clients.
Oh yeah, definitely. And sometimes, you put information out there, and people on the other side maybe that or sometimes other people are reading your stuff too that aren't potential clients, and they're reading it because sometimes they don't always like what you write, and sometimes that's tough, because you just kind of call it as you see it.
That's right. That's exactly right.
But
for those of you just joining us, I'm talking with Jon Rehm, Nebraska attorney who handles work comp and similar practice that we have. I want to welcome Brigitte, Shelley, and Mom to the show. If you guys have got any questions, just throw them in the comments section. Jon and I'll be glad to field them. But we're talking about social media. We're talking about how to manage your clients' activities and actions when they're not actually sitting there with you. And let's kind of slide into that, Jon, for a few minutes. Let's talk about social media. Let's talk about those headaches and those things that our law practices we didn't have to worry with before social media came around, but they're absolutely part of our practice, and I suspect they are for you guys as well.
Absolutely. I don't know. I think that there's kind of three knots of social media that I want to talk about to anybody watching. First of all, social media is not private. And I think a lot of people think that, my Facebook network is, I'm only talking to my friends and family, or maybe my Twitter account's protected. But the fact that you're talking to maybe hundreds, if not over thousands of people about intimate details of your life means it's not private. There's no very minimal, you can't expect that to be private. It's just like you're walking out in public. So it's not private. The other thing about social media it is new, but it's not new. What social media, I think, is why it's a problem in litigation is because even before social media came around, you had private investigators would videotape people out in public, particularly in workers' comp cases, and even coworkers, bosses would spy on people. I see that, especially in a smaller town in Nebraska. People are driving home and they see they see somebody doing something they think they shouldn't be doing. So, it's not new, but what's more dangerous about it is that it's cheaper. Whereas before, social media came around, you wanted to catch somebody doing something, you had to hire a private investigator. Then that private investigator that may not get into evidence in court. Social media, it's a lot cheaper, to get to find that, and it's easier, I think, to have that come in. And I don't think it's necessarily fair as well, but things aren't fair. And And I think there's an emphasis on people kind of getting busted on social media because there's this presumption that workers' comp cases are either fraudulent, people are scammers, they're milking the system, and those people are an exception to the rule. But again, that whole idea of somebody getting caught doing something they shouldn't have done on social media if they're injured in a work injury or a personal injury is something that you just have to deal with. It's not fair, but that's just the way it is.
John, all you need is one of these to become an investigator these days, and everybody's got one of these.
Yeah, and people can. I think my clients can certainly. I've benefited. You've probably benefited from things that clients have dug up on their smartphones or been able to bring back on their smartphones. But it just works both ways.
What are those things? How does your law firm stay in touch or educate your clients about how to deal with social media during the time period of you guys representing them in a claim?
Well, I mean, you tell people, look, I mean, your people are, your social media, you tell them it's not private. People are going to be looking, coworkers are going to be looking, the insurance company might be looking, the other lawyer might be looking if there's a lawyer involved. So you just educate people and say, look, that there's, anything you do is potentially could be fair game in an injury case. So you educate people, and you educate people about it. If you get involved where you have to formally go to court, you're going to probably want passwords and things like that. You're going to want to look at profiles. So, sometimes you look if people see what's available publicly for clients. So, but it's mainly just through education, and again, I think the vast majority of clients are fine, but it's always, it's the 5 or 10% that you maybe where there's some trouble or where there's some issues.
We've gone so far as one of the responsibilities for one of the paralegals here, we call her the social media czar. She actually takes a handful of clients each day and stalks their social media to see if they've done something that could potentially be harmful to their case, which leads me into our first question from Shelley. Should I remove items I have posted on my Facebook page? Excellent question.
Well, I'll give you a real lawyerly answer. It depends. I think it's a good. I think before you get involved, I think anybody, whether you're an adult or a child or whatever, it's not a bad idea to kind of go back through your social media accounts and update stuff that's maybe not accurate, take down stuff that may be embarrassing. It's not a bad idea, period, for anybody, lawyers,
right.
Anybody to kind of go back and look at those accounts and say, look, maybe you need to update stuff, clean stuff out. But when you get involved in a case, if you start a court case for either a personal injury or workers' compensation, maybe you have a wrongful termination case. If you start a case, then you're you're obligated to, you have a duty, or you must try to preserve evidence. And if you're involved in a formal case and you take down something on social media that might be relevant to you, that's called spoliation. And if the other side finds that out, you could be in deep trouble. That's something that's almost a case killer. It's concealing, it's lying. So if there's something going on, if you've initiated a court proceeding, you probably don't want to, you don't want to take down bad stuff. And if there's bad stuff on there, you probably want to talk to your attorney about it. So,
it's almost like you tell your children, always tell the truth. And if you're not going to tell the truth, then don't cover up the lie, because then it just compounds it and makes it worse. And I think that it's applicable to Facebook or to anything with social media, things like that. If you're going to take stuff down and then lie about it, you're right. It's inevitable that maybe somebody's already stumbled across it and taken a screenshot or a computer image of it somehow. Because the last thing you want to do, at least my experience tells me, John, is that clients' credibility makes or breaks any workers' compensation case.
It
And
does.
you don't want to give reason for them to doubt you.
Yeah, and I think in a real practical nuts and bolts standpoint, clients always want to know, well, what's my case worth? Well, let's say your case is worth $100,000 settlement, and then maybe there's evidence of dishonesty on a social media feed, and that $100,000 case is maybe worth 50 or 25. I mean, it goes away with that. So again, and again, especially depending on what kind of case you have, it can really be devastating. So you don't want to take down bad stuff, and you want to talk to your lawyer about what, hey, there's some stuff on here that you should know about. It's easier to explain away bad facts than it is to explain away a lie. I mean, and again, this goes back to, when private investigators, and they still do this, would monitor clients, and maybe you got a picture of somebody with a back injury and they're playing with they're tossing their kid up in the air in the pool or something, and then there's videotape of that. Then as a lawyer, you go back and say, okay, how did you feel after you did that? Well, I was in bed for 2 days. I was in a lot of pain. So you can explain away things like that, but the lies and the cover-ups are much more difficult you really can't do much with that, so.
Plus, it also gets into you as their lawyer and your reputation at times. Do you really want to appear in front of Judge X with a client that has got all of these issues? So I know it just compounds the issues that you have to deal with between attorney and client, but even before you get to that next phase.
Yeah, it's true, and in particular in workers' compensation, where, I mean, you're probably in front of a very small set of judges at least in Nebraska, there's only 7 that hear them, and
Wow.
Yeah, we only have 7, so I mean, yeah, you want to make sure, that you hear that, that that you have credible clients. Yeah, you don't want to undercut other cases for a weak client. So
That's exactly right, because you're going to be doing this work for a long time where it may be their only case.
sure.
But for those of you just tuning in, watching us live or watching us later on, I'm talking with Nebraska attorney Jon Rehm, and we're talking about social media and how to deal with those issues when representing clients, because sometimes it can really harm a case. On other occasions, it may be helpful to your case. But John, we got another question. Will adjusting my privacy settings to the highest level help as opposed to deleting items that I'm concerned with? How would you deal with that?
Yeah, I think it's advisable to adjust privacy settings for it. But the only effective adjusting privacy settings is that somebody who's like a legal assistant or a paralegal who's investigating somebody on Facebook can't see much. I mean, you get into a lawsuit, you get into you get into a formal case, for the most part, that other lawyer is gonna be able to see the your settings regardless of the privacy settings. But the privacy settings make it easier, I think, to make it harder for the other side to see what's out there. So I mean, it's not foolproof, but again, it makes things a little easier makes it harder for the other side to catch bad stuff. So but again, just having privacy settings doesn't mean that the other side can't see that account.
Well, to me, the best practice is either to not have a social media account at all, or to just let it lie dormant until after your case is over with. And that's what I wanted to get your thoughts on that, as well as after the case is over, are there still concerns when it comes to social media and posting that the clients should be concerned about?
Yeah, let me take the questions in order. Ideally, yeah, it would be great to represent clients with no social media and everyone, and so sometimes you get people that don't have social media, that really aren't on social media, and that would be great. But I think here's the problem with that, from my point of view, is it's social networking's networking, and if you're hurt or if you've been laid off and you're trying to find work, if you're not on social media, then if you don't have an account, you're not, it's almost like you're isolating yourself.
Mm-hmm.
And I also think that to some extent, social media has, it's how you connect with people. And if you have, part of the problem with being an injured worker is maybe you're at home, you're in pain, you're isolated. And I think you and I deal with this. We have some clients that are just very lonely and hurt people. And I think social media can be a way for people to stay connected. So if you have, it's just part of life. And I wish people would use social media better, but I just tell people to be careful. And I personally, I don't, for the reasons I said before, I really don't think that you can tell people not to use social media. And I think that, other lawyers may disagree, but I think that, you gotta be safe with it. But you still, I think you should use it, because it helps with jobs, family connections, things like entertainment. So whatever.
Mm-hmm.
But
what about the second part? What about after the end of a case?
Well, yeah, that's a different story. I think you gotta be, prudence is good at the end of a case. And I think that where social media after the case comes in is more, I've never heard about it in workers' comp or personal injury, because at least in our state, workers' comp settlements are public record, so that you can't make them confidential. And really, I think a lot of insurance companies don't necessarily have confidentialities agreements as part of settlement agreements. But when you get into wrongful termination cases, either, let's say you initiate a formal case, you do a formal case, or you come to a severance agreement. When you settle an employment law case, usually, almost always, the other side wants confidentiality as a condition of settlement. And in oftentimes, considering, what they're offering, and it's worth, it's worth taking, it's worth settling that case. What can happen, though, is somebody gets a settlement particularly in a wrongful termination case, and they say something on social media, and then the other side can come back and take the money back. It's not just a matter of in an injury case where, saying something dumb or doing something dumb on social media reduces the value of your case. In an employment law case, after, if you breach a confidentiality agreement, you're looking at giving that money back. Yeah. And there was a case in Florida where a daughter posted something. We had a case here in Nebraska that went up to the Court of Appeals, went up to one of our appellate courts here in Nebraska, and they said, yeah, the guy that negotiated a severance agreement and then went on a Facebook, like a private group, and started bad-mouthing his employer, had to give that severance money back. And, that's, it's one thing to lose, to have your case be reduced. It's another thing to have to give it back, particularly to an employer that wrongs you. So, you got to be real careful with confidentiality agreements and things like that. And again, it's not fair, because I think most people are smart about things, and I think also employers to some extent will still talk. And there's also kind of a time period when you're trying to get a case resolved in an employment law case where it's kind of purgatory. But again, employees, especially in employment law cases, if there's a confidentiality agreement, you got to be, you got to be very careful about what you say on social media. So
it is, and it just seems like that it's human nature to want to get it out, and by getting it out, it's no longer just that people want to talk about it at the dining room table, or if they're out to dinner with some friends, they want to get it out on social. I don't know why, but it just seems that is the majority, at least of my clients. They just have to get it out somehow. and you can only do so much. They're adults. They've got to make adult decisions, and sometimes that's a frustrating part of this. But Jon, we're getting close to the end of our discussion, and I appreciate your insight and your expertise. And I want to conclude with this. I want to ask you to share with us a few tips, a few ideas, things that you share in that initial meeting with a new client about how to be safe in their communications and in their, not just on social, but when they're out in public. What are things that you advise your clients that they really should be mindful of during this time when you're representing them for a work comp injury claim?
For a work comp injury claim, I always tell people just assume you're being watched. Just assume that whatever you say or do, you're gonna be watched. I mean, you tell people you're whatever expectation you have of privacy kind of goes out the window in workers comp. And again, I would advise everybody, whether they're a workers comp claimant or not, anybody listening, monitor your own social media accounts, check your privacy settings, be careful about it. But again, we have Todd Bennett, one of our partners, he's a Hill Street Blues fan, is always concludes our lawyer meeting with, be careful out there, and it's just be careful, and again, I'm of the mind that you can't, I'm 43. I mean, I'm maybe a little younger. Social media is part of life, and you just have to you just got to be careful with using it. Other lawyers, again, maybe disagree, but I still think that it serves a purpose, and you have to be careful in how you're using it. Just assume that you're being watched.
Common sense should rule the day, but that doesn't necessarily mean that it's going to, unfortunately.
Yeah, that's right, but I do think that most people do exercise common sense. I think most of my clients are again pretty good, but it's always the few people who kind of ruin it for everybody.
Well, if they'll look at the big picture, what's the end goal? What are you trying to accomplish? Maybe some of that will resonate with them before they mouth off or do something good. And Jon, I can't thank you enough for your time.
And I appreciate the opportunity to be on. This is an honor and a privilege. So.
Well, it's been my honor and my privilege to hear from you and your expertise. How can people get in touch with you or your firm? I know you're not just in Nebraska, but what is phone number, website, those kind of things?
www.rehmlaw.com. Our 800 number is 800-736-5503. We do a lot of interstate trucking cases where sometimes you can get Nebraska jurisdiction, even if you're hurt outside of Nebraska, if you have a Nebraska employer. So the Nebraska workers' comp law is actually fairly favorable in comparison to a lot of other states. So, and sometimes you can collect in both states too. So yeah, I know rehmlaw.com, rehmlaw.com, and our 800 number is 800-736-5503.
And we'll make sure we put all that contact information in the comments section.
And read my blog, read our firm blog, NebraskaWorkersCompensationWatch.com. So,
well, for someone who regularly reads it, I can attest it's got some great information that applies mainly to Nebraska laws and rules, regulations, but it has a lot of applicable information that it doesn't matter what state that you're in. And I saw we had a late question, but we've already addressed that. But Jon, thank you again. And guys, as always, we really appreciate your support and watching and participating in our weekly show, NOMBERG Law Live. This will conclude our talk for the day. We'll be back with you again next week. And Jon, I hope you have a great rest of your week. We'll talk to you again soon.
See you later, sir. All right. Bye-bye.